In order to answer this question, I think it's a good idea to take a couple of steps back to develop the reason why we have exemptions in the first place. Because for the uninitiated, this term may mean nothing whatsoever. So exemption exists both inside and outside of bankruptcy. Outside of bankruptcy, the idea is that if somebody sues you, you shouldn't end up living under a bridge with just the clothes on your back. So the idea of exemption is to protect some of your possessions so that you get to keep them after a judgment has been entered against you. The creditor gets to collect against a lot of your stuff, but not everything, so that you're just stripped bare. Now, in bankruptcy, there are a couple of reasons why we have these exemptions. The first is really the foundation for the others, and that is in a Chapter 7 bankruptcy, what happens? Well, debts just go away without you paying anything at all. You don't pay a dime to your creditors on the dischargeable debts. So, of course, from those creditors' perspective, that's a pretty heavy hit. And as a result, there are some limitations. One of the limitations is on what you get to keep. You get to keep some stuff, but there's at least the potential to lose assets in a Chapter 7. So one of the things we include in a set of Chapter 7 bankruptcy papers is a complete listing of everything you own or have an interest in. And all of those assets get divided into two categories: exempt, non-exempt. The exempt stuff, that's yours to keep. The non-exempt stuff is fair game for the Chapter 7 trustee appointed to your case to seize and liquidate and have money to distribute to your creditors. So how do we determine whether something's exempt or non-exempt? Because that's obviously the big ticket issue here. Well, we use in California one of two exemption tables. Now, the Bankruptcy Code is a federal statute, and it does have an exemption table in Section 522. But the Bankruptcy Code permits the states, if they want to use their own state tables. California is unique among the states in that we don't use the federal table at all. We've completely opted out, and we have two state tables. One table is for homeowners with equity. The other is for everybody else, the so-called renters table, but homeowners can use that if they wish. Each table has a list of various categories of possessions. Some categories have dollar limits, others have no dollar limits. And our goal, as we prepare your petition, is to list your assets and stick them into these categories so that they're protected from the depredations of the Chapter 7 trustee. I said that there are other reasons for this exemption process. They are found in the other two chapters under which most individuals and married couples file for bankruptcy protection, Chapters 11 and 13. And then there's also Chapter 12, but in this part of California, we really don't get those. That's for family farmers and commercial fishing operations. So what does exemption have to do with those chapters? Well, in those chapters, we propose a plan of reorganization that will repay creditors over time. Now, there's some overlap in the concept in Chapters 11 and 13, but there are some fundamental differences that are a little bit beyond the scope of what we're going to talk about today. One of the requirements in both chapters that the plan must satisfy, unless creditors accept some other treatment, is that a creditor must get paid at the very least over the life of the plan what it would have gotten if you had done a Chapter 7. Now, this is usually a bit of a puzzle for folks when they first hear that, because their immediate response is, wait a minute, I thought my debts just went away in Chapter 7. They don't get anything at all. Well, in most Chapter 7s, that's correct. They are what are called no asset cases. But in some Chapter 7s, creditors do get paid. From what? Well, if you have non-exempt assets, then the Chapter 7 trustee takes those assets and liquidates them and has money to distribute to the creditors. In a Chapter 13, in a Chapter 11, you keep all your assets. No trustee is going to take any of your stuff. But we still go through the exercise of listing all of your possessions, dividing them into exempt and non-exempt categories, because whatever the dollar value is of the non-exempt pile, that's what the creditors would have gotten if you had done a Chapter 7. In a 13 or an 11, you keep that stuff, but we still go through that exercise so that we can determine the dollar amount that the Chapter 7 liquidation would have paid to the creditors, because that then is the minimum that you can get away with repaying the creditors over the life of the plan. And that goes into the analysis to determine what the monthly plan payments will be. So in California, to sum up and to really get to the heart of your question, we have two exemption tables, one for homeowners with equity, the other for everybody else. And in some of the other questions today, I think we're going to get into the weeds on what those tables contain. So I think we'll just leave it at that for this question.